Good morning. We'll begin the docket today with the Rule 20 oral argument, which under Rule 20, each of you have 20 minutes to present your oral argument. That 20 minutes does include any rebuttal time for the petitioner, and you're automatically entitled to that rebuttal time. You'll notice that in the courtroom, we've installed plexiglass on the bench for the justices. So the justices are able to remove their mask during oral argument because they're also the requisite number of feet away from any of us within our courtroom. We've also put plexiglass on counsel tables, so if you choose, once you approach the podium to make your oral argument, you may remove your mask and put the microphone cover on. With that, I will call your first case. J. Lawrence Smith versus Angela B. Van Meter, the Clerk of the Circuit Court of Grant County and the Grant County Commission. Docket number 19-0679, an appeal from the Circuit Court of Grant County. You may proceed.
Good morning, counsel.
Good morning. May it please the court, Robert W. Bright of Middleport, Ohio, on behalf of Appellant J. Lawrence Smith. Appellant Smith is a freelance journalist who needed to get some copies of public records from the Grant County Circuit Clerk's office for an article he was intending to write. He was told the copies would be $1 per page. Working as a freelance journalist doesn't pay very well, so he was concerned about the $1 a page adding up quickly as he made copies. He inquired whether he could just take photos of the documents he needed to avoid the expense. Clerk Van Meter told Appellant Smith that she was obligated to charge him $1 per page for the copies of the documents, even if those copies were digital copies that Smith had made himself with his cell phone. Smith decided to leave the clerk's office without the copies. On November 30, 2018, Appellant Smith sent Clerk Van Meter a FOIA request asking for copies of several documents in 4 cases. Smith enclosed $5 to cover the costs. Clerk Van Meter replied that she was obligated to charge copy fees according to West Virginia Code 59111 of $1 per page. Smith noted that the FOIA law at West Virginia Code 29B required that fees charged for photocopying records be reasonable and based on the actual cost of making the copies. Clerk disagreed, and Smith filed suit in the Grant County Circuit Court. The Circuit Court dismissed the suit July 1st, 2019, and that resulted in the filing of this appeal. This case is about whether government officials can charge citizens exorbitant copy fees when no physical copy is actually being made and when the government official isn't actually involved in rendering service to make the digital copy. The clerk's incurring no expense related to the digital copies. No ink and toner is being used. There's no paper being used. The physical copy machine is not suffering wear and tear. The relevant statutes are found in West Virginia Code 59111 and 29B13. 59111 is the primary statute regarding circuit clerks and copies. It states that the clerk shall charge and collect for services rendered by the clerk the following fees. For a copy made by the clerk, $1. 29B13 is the FOIA statute and states the public body may establish fees reasonably calculated to reimburse it for the actual cost in making reproduction of the records. It's unlikely that a circuit clerk's actual cost to make a physical paper copy is $1, in my opinion. I charge my clients 10 cents per copy, and that more than covers my costs of paper and toner and things like that. There appears to be an apparent conflict between the FOIA statute and the general statute. The general statute appears to support clerks ostensibly generating revenue by making physical copies for citizens who request copies. If that's what the legislature intended, then fair enough. Appellant Smith's purpose here is not to challenge the statute or to overturn the statute. His position is that the statute's simply not applicable to him taking photos of public documents, and further that it's really exorbitant for a clerk to be allowed to charge $1 per copy when the clerk is not rendering any service in actually making the copy and is not using any supplies. Appellant Smith's experience arguably raises equal protection issues, given that a number of circuit clerk's offices, he listed 10 that I put in the brief, have allowed Appellant Smith to take digital photos of public documents without charging him any fee at all, much less $1 per page. Indeed, in my experience, I've been in a circuit clerk's office that let me do that. The applicable statutes are inconsistent and do not contemplate all possible scenarios. That's resulted in various circuit clerks having inconsistent policies related to the taking of digital photos of public records. As noted in Appellant Smith's brief, a number of states have found that it is impermissible for public officials to charge citizens for taking photos of public records. I've listed 5 or 6 states, I believe, and some of their citations in the brief. Appellant Smith argues that West Virginia should take a similar approach. On the other hand, Appellee's brief emphasizes that there is no statute that requires circuit clerks to allow Smith or anyone else to take photos of public documents. Appellee's argument misses the point, I think, and that point is liberty. There should never be a need for a statute requiring clerks to allow people to take photos of public documents free of charge. That should be presumed, given that liberal access to public documents is a principle of open government. The better question is whether or not the existing statutes prohibit the clerk from allowing photos of public documents to be taken free of charge. It's clear that neither statute applicable to this case prohibits that. The foundation of American government is to work from a presumption of freedom, not from a presumption that a statute needs to be passed to give a citizen permission to do something. The Constitution of the United States and the Constitution of West Virginia preserve any rights not explicitly delegated to government as reserved to the people. As such, it should be presumed that taking photos of public records without charge is permissible. The legislature's silence on the issue is permission until the legislature sees fit to revise the statute to say otherwise. I thought that maybe the statute was so old that they hadn't considered cell phones and cameras and things like that, but it appears it was revised. The general statute was revised in 2018, so they could have addressed it there and didn't. As such, Appellant Smith moves the court to reverse the decision of the circuit court below and remand the matter to proceed towards discovery and trial. Appellant Smith would also ask the court to resolve the conflict between the applicable statutes and/or formally decide whether or not it is permissible for circuit clerks to charge $1 per copy for photos citizens may take of public records.
So my question is, why do we even need to consider FOIA? Or maybe your answer is because the circuit court looked at it. I mean, in this case, the journalist was in the clerk's office looking at the court files, correct?
Correct.
So there wasn't a FOIA request?
Not at that time.
Not at that time, it was later. And was there anything about this file that was confidential or burdensome, or this court file that the journalist was seeking to take photos of, that was either burdensome or confidential or some other reason for the charge to be given?
Other than the cost of the copies, I haven't seen any of that objection related to this case. I can understand the concern. Some cases are sealed and so on and so forth.
But this case was not sealed.
He was looking for records related to a gang of drug dealers, and so that would have presumably all been open. They were all adults, and it was 4 cases. The FOIA request was about 4 cases that involved a drug ring in the county.
Thank you.
You've indicated that the statute was dealt with in 2018, and maybe they didn't foresee it. Well, let's take it one step farther. This court and the circuit, many of the circuit courts in the state of West Virginia have moved to electronic filing. So how are we going to deal with that? I mean, if he's not looking at a paper file where he can take a picture, what are we going to do whenever it's on a computer screen?
And I'm not sure the answer to that. Just before the session was called into order, was talking with opposing counsel, and when I log into the e-filing system for Mason County and Jackson County, where I practice some, I'm right across the river in Middleport, Ohio, I can only see the documents that I filed. And I had a situation where, in a divorce case, opposing counsel was replaced with new counsel, and he couldn't see anything in the file, so I had to forward him all the documents to avoid him having to pay the $1 a page. So I don't think the system's quite yet ideal, but I don't know how we work with that.
What in your ability to discern any sort of legislative history, is the dollar per page for the toner and the paper and the staff as a direct reimbursement in terms of what the legislature authorized the copy fee to apply to, or was it generally to address the general expenses of operating the clerk's office and their daily activities in general? Are you able to discern what that dollar per copy was intended to go towards?
Unfortunately, Your Honor, I can't. My client was not particularly well off, and he ended up getting an organization out of Washington, D.C. that works with journalists to pay his attorney fees, and we were on a pretty tight budget, so I didn't delve that far into the statutory history.
The other question is relating to the FOIA. We've got two assignments of error here in the second relating to FOIA, and mindful of what my colleague Justice Walker mentioned. But part of the petitioner's complaint here is that he offered the $5 that was refused by the clerk. But doesn't the FOIA statute make it clear that it's really up to the clerk to determine what a reasonable fee is, and that the petitioner here, in simply offering $5, it's not within his province to make that decision? So isn't that an error on his part, and that the clerk acted properly in refusing the $5?
To be clear, I think that's probably the case. It looked to me like the number of copies that he may not have known how long the documents were, but as it ultimately turned out, I think it would have been significantly more than what $5 probably would have covered. So that in itself was probably an error on his part, yes.
And I noticed that several other states' attorneys general have issued opinions that have provided some guidance. Any attorney general opinion in West Virginia relating to the definition of a copy that we might look to?
Not that I found, Your Honor.
And the easy fix theoretically would be for the legislature to, whether they addressed the statute last year and intentionally avoided it or felt there was no need to address it, the legislature could easily fix this, could they not?
Agreed.
Thank you.
Counsel, I know there are some agencies that will simply waive charges, and some that, depending on how much is asked for. Is there anything unique about this circuit clerk's office that, I know the statute relates to that specifically as opposed to other agencies, but is there anything unique about that situation that justifies the $1 versus other agencies that waive that or have a lower fee?
I don't know, Your Honor. I imagine learned counsel for the appellee will probably address that sort of issue. I've never appeared in Grant County, so I don't have any familiarity with their system at all.
I wasn't even really relating necessarily just to Grant County, but the idea of a court record or a circuit clerk or county clerk record.
Yeah, I can't speak to that. I'm sorry.
Any additional questions? Any comments?
None.
Would you like to reserve your time for rebuttal?
Sure.
Yes,
I don't know if I'll take
thank
it.
you,
I'll reserve
counsel.
it. Thank you.
For the respondent, counsel.
May it please the court, my name is John Hours. I'm the prosecuting attorney of Grant County. I mentioned that simply because, and no deference to the clerk, when I looked at the docket, it said that the appellee was represented by the law firm of John Hours, and I am not a law firm. I am the prosecuting attorney of Grant County. I want to start off by saying and respectfully argue that I don't think Judge Nelson did anything wrong at all in his decision. When we were there and he made it, Mr. Smith, he asked him, can you give me any authority that allows you to take pictures of the records in the circuit clerk's office? And truthfully, he said, no, I cannot. He tried to argue the FOIA statute, and you all, as you all have clearly indicated by your questions, he certainly didn't comply with the FOIA statute in any way. There is a conflict in the laws, but I think I can perhaps explain it. The legislature has historically provided a statutory fee to be charged by both the circuit clerk and the county clerk for copies. When the FOIA statute came into being, there were no statutory fees for any of the other governmental agencies. I knew little about FOIA before becoming the prosecutor, and I didn't know it, but upon becoming the prosecutor, I had to answer every FOIA request sent to the courthouse in Grant County. So I've regretfully become a little bit familiar with it. Now, don't get me wrong, I am a person that believes that sunshine is the best cure for everything, but some of the FOIA requests that I have had to respond to have been something else. I won't get into that. When the legislature passed the FOIA statute, we have to presume that they remembered or knew that they had a charge already on the books for these two places and didn't for any of the other governmental authorities, and thought, how are we going to break this down with every branch of government? And no disrespect to the legislature, once in a while they do things that amaze us all, and I'm being sarcastic for a second. But when they passed this reasonable fee business, I don't find anything wrong with that at all. To answer a little bit of a question about the uniqueness of the circuit clerk's offices, as all of you are aware, in the circuit clerk's offices there are all kinds of records. You can't get into a divorce file. The public is not allowed. You can't get into an adoption file. The public is not allowed. You can't get into a juvenile file. You can't get into a mental hygiene file. You can't get into a conservator file. Why? Because of the privacy. Now, what is the expense that you made inquiry about, or the uniqueness of our circuit clerk's offices? I think the count now is 25 with e-filing, and someday that's going to be great when all the bugs get worked out. But the remaining circuit clerk's offices in this state, I haven't been in all of them, but I've been in most of them in the Eastern Panhandle, and a lot of the courthouses are old with limited space, and you walk into a room called a vault. Kind of like a vault at a bank. It's a vault for a reason. Safety. Now, I don't mean to cast any disparaging remarks to Mr. Smith, but his very title, an investigative reporter. The circuit clerks are under a duty to protect those files that the public is not allowed to get into. And if this court believes that each one of those types of things is in a separate little vault somewhere, that's not the way it is in most of the counties in the Eastern Panhandle. I did a lot of work in Pendleton County. Everything's in a little tiny room. They have e-filing now, and that's not a problem. They have a public terminal, and the public can't get into those prohibited places. Someday this is going to be perhaps a moot question when we figure out what someone has to pay to get paper copies from the e-file terminal. The definition of copy, a very good question, as far as I know, has never been defined by this court or by statute or by statutory definition. And with no disrespect for counsel for the appellant, if you look at the very first sentence in his brief, he called the photographic images that Mr. Smith wanted copies.
Counsel, let me ask you.
Go ahead.
I was just going to ask you, you started out talking about there's no law saying that you can do this. And counsel for the appellant is saying there's no law saying you can't. So let me just ask you this. If you, would you agree that if someone walks in with a legal pad and wants to just transcribe a document, that there would be no charge for doing that? If I'm not taking a picture of it, I just want to take a legal pad in and just copy verbatim what it says.
I never thought about that. When I do that as an attorney, I take notes. I don't verbatim do it. I'm not going to be a fool and argue that, yes, she should go through your notes and charge $1. And I agree that technology is a wonderful thing. And what I want to say, looking at you, no disrespect intended, I think we can all remember before there were cell phones and before there were cameras in all phones.
I guess where I'm getting at, so I can clarify my question, I don't know of any statute that says I can go do that either. I could go just make notes from a document, but the sort of the default position is unless the statute prohibits it, I'm allowed to do it. So why is that? Why does this not fall in? There's no statute, unless you can point to one that says I can't go in and take a picture of it. Why does the default position suddenly become that unless there's a statute allowing me that, I'm not allowed to do it?
Well, I want to answer you this way, and I don't know if it's the right answer. Angie Van Meter, the circuit clerk in Grant County, it was her first term, and she'd gone to the schooling that a clerk goes to, and she was taught any copy leaving your office is a button. Now, I'm sorry for giving you that short answer. Again, I want to say phones in the vaults of the West Virginia circuit clerks without e-filing can and will be a problem when someone with a wrong motive, with a wrong idea, gets into a place where he or she shouldn't be and starts running the camera. It is my experience that our circuit clerks are very trusting and perhaps too trusting, and maybe that trust only extends to the bar.
But let me stop you there and emphasize that this case is not about casting aspersions or not on this circuit clerk or any other circuit clerk. I think we're really just looking at what a statute says and setting aside the importance of a discussion about cell phone copies versus transcription, which I thought was a great question. Isn't the key phrase in 59.111B2 made by the clerk? And in this case, the copy that it was sought to charge $1 for was not made by the clerk? How do you get around setting aside the whole, what's a copy, what's not a copy, what's a transcript, what's not a transcript? How, doesn't it have to be made by the clerk in order for a charge to attach?
That's a very good question. If I may for a moment, I want to refer to something in my reply brief, if I may. I'll try to be very short. Upon reflection, that's even a better question than I thought. I have to agree with you. I have to agree with you. I do want to say this because I'm about finished unless there are other questions. In light of what Judge Nelson was presented with, I don't think that he committed error. I think that this conflict, as you have indicated, Chief Jenkins, maybe is something that the legislature ought to address. Technology has caught up with the legislature. I admit that. And I think that while the legislature's thinking about it, if they think about the answer that Justice Hutchinson wanted with regard to the e-filing public terminals, we'll be in a better place. But I again do not believe that upon what was presented to Judge Nelson that any error was committed. Thank you.
Thank you, Councilman. You have a few minutes for rebuttal if you wish to use it.
I think the only thing I would like to address is Council's concern was that Mr. Smith or someone else may be in the vault with confidential records and so on and so forth. And that theoretically could be the case. I don't know that that was part of the factual basis underlying this case. None of us can control what a clerk allows or doesn't allow other than the clerk, and if they have any supervisors. I'm not sure how that works here in West Virginia, but it seems to me that a clerk can get a file that is not confidential and give it to a journalist and let them review it, take notes on it, take photos of it or whatever. Just because there's a possibility that someone could be allowed in a vault and take photos of something they shouldn't isn't an argument that directly relates to this case, I guess is the point I'm making.
Well, maybe it does though, because what you've said was always my experience whenever I practiced law. I did it in southern West Virginia. But what you would do is you go to the clerk's office, go to the counter. If you needed to see a file, and you'd have to tell a deputy, say, I need to look at this file. Deputy would have to go to the vault, dig through the files, bring it out, let you look at it. And so part of that takes up the time of the deputies. And so the dollar fee, is that not a way to acknowledge that your inquiry is taking the time of a clerk, and that if you're going to take if you're going to get a copy of a document that clerk's had to go find for you, that you ought to pay a little bit for that process, essentially. And so I guess my question is, if that's what's having to happen, doesn't the dollar fee that's established by the legislature make some sense?
It's an issue I've thought about since filing the briefs and all, and I agree that is a service the clerk is rendering, or the deputy clerk is rendering, before the person starts making the copies with the cell phone or whatever the case may be. Suppose if I were a legislator, I might propose that there be a minimal fee charged to pull a file, and then the person could take the photos or whatever they needed to take. The dollar fee, though, I mean, say someone needs to copy an entire file and has 300 pages in it. Well, then you're talking about a $300 fee to pull a file. So that's what I mean. I think a minimal fee to pull a file would make more sense than $1 per copy.
Well, Counsel, going to that question, in 29B1-3E, the last sentence there, a public body may not charge a search or retrieval fee or otherwise seek reimbursement based on a man-hour basis as part of costs associated with making reproductions of records. So how does that comply with this $1 fee? I mean, if part of that fee is related to what Justice Hutchinson just outlined of the cost of that clerk going and taking time to go make that copy, isn't that inconsistent with that part of the statute?
Seems like it is.
Anything further? Any additional comments, counsel? In this case, thank you both. This case will be submitted.
Thank you. Don't you just hate it when they say, well, that's a good question?
Madam Clerk, can we mute for a moment? Can we mute for a moment?
All right, counsel, this case is going to be argued under Rule 20, which provides that each of you have 20 minutes to present your oral argument. That includes both the opening and the rebuttal for the petitioner, so there's no need to reserve time. You just need to self-monitor your time. There is a clock to the left of the podium on the table so that you may self-monitor your time. You'll notice in the courtroom we've installed plexiglass on the bench. In addition to that, the justices are far away from us in the courtroom, so they may remove their masks in order for you to understand their questions a little more clearly. Also, on counsel table, we've installed plexiglass, so if you choose, when you approach the podium, you may put the microphone cover on the microphone and remove your mask to present your oral argument. With that, I will call the second case for oral argument today. West Virginia Department of Health and Human Resources versus CP, docket number 190802, an appeal from the Circuit Court of Webster County, West Virginia. Counsel for the petitioner, you may proceed.
Good morning, counsel.
Good morning, Mr. Chief Justice, and may it please the Court. Thomas Lampman, Assistant Solicitor General on behalf of the Department of Health and Human Resources. A layperson who presents and discusses facts before the Board of Review is not practicing law, and the Department's rule authorizing this practice does not intrude on this Court's power to regulate the legal profession. When the Circuit Court decided to sua sponte strike down the Department's rule, a rule that dates back at least 3 decades, it not only exceeded its own powers, but it broke with the precedents of this Court and with the decisions of other state high courts addressing the same issue. The decision below was substantively wrong in 2 critical respects. It gave no weight to the nature of Board of Review proceedings, and it misconstrued the scope of the activity in question. Correcting the error below is thus an opportunity for this Court to clarify on a practical level what is and what is not the practice of law in Board of Review proceedings. So long as a layperson is assisting with discrete tasks in the confines of a particular case, they are not practicing law. In contrast, if someone is directing the course of a proceeding overall or affecting multiple cases before the same tribunal, that may rise to the level of practicing law. So turning first to the nature of Board of Review proceedings. The significance of the proceedings' nature in question was set forth first by this Court in Friesen v. Eisner. This Court spelled out the characteristics of proceedings where layperson advocates are appropriate and are not practicing law. These proceedings are informal, they use streamlined procedures, and they often proceed before a decision maker who is not themselves an attorney. The Court described these sorts of tribunals as people's courts, designed to be accessible, in which a layperson can appear and speak on behalf of a third party. Now, in the Circuit Court, or in this Court, this sort of layperson advocacy would be the practice of law. There's no question there. But that's not so in these limited tribunals. So the Circuit Court was therefore incorrect when it said that the character of the proceeding in question is of no moment. And in fact, the character of the proceeding in question here is highly relevant. Board of Review hearings are a forum, much like magistrate courts. They proceed as quasi-judicial proceedings in which a layperson can assist a party with presenting its case.
Are you saying that where an individual commits certain acts determines whether it's the practice of law or not?
Yes, Your Honor. The nature of the proceeding in question. For example, in this case, we saw a department employee didn't merely present exhibits and explain what the department's position was, but questioned the petitioner or the claimant on the other side, and at the end gave a summation of the facts of the case to the decision maker. In Circuit Court, we would call that a closing argument, but in an administrative hearing, in a more informal proceeding, not governed by the rules of evidence, that's a characteristically different act.
So you're saying then that in an administrative hearing, anyone may appear and whatever they do, it does not consist of the practice of law?
Not precisely, Your Honor. Friesen even made clear that this isn't, in these proceedings, these sorts of people's courts, a layperson advocate can appear for the purpose of assisting a party. But it's not to say that any action they take in any way, shape, form, or fashion doesn't rise to the level of practice of law.
Give me an example then. What type of action could they take that would rise to the practice of law?
In Friesen, Your Honor, the layperson advocate held themselves out to the public as an advocate for hire, represented multiple clients in multiple proceedings over a long period of time as essentially their business model as a debt collection agency. This court recently decided Gomez and Shenandoah Sales, both of which dealt with not necessarily repeat advocacy, but more holistic sorts of advocacy, where someone is directing the entire course of the proceedings. Amicus briefs filed in this case have also described advocates before administrative hearings, but advocates that have filed multiple motions respecting legal issues, applying legal judgment to particular sets of facts. Those sorts of activities do rise to the level of what has been described as the practice of law and how this court has defined the practice of law, the application of legal judgment to a particular set of facts. But again, that's the sort of holistic advocacy and the sort of complex advocacy that we don't see in Board of Review proceedings. Board of Review proceedings, if you look at the roughly 2,000 cases the Board of Review hears in a given year, only a minute handful of those are ever even appealed to the circuit courts as raising any sort of legal issue. I believe in 2019, the one attorney I spoke to said in the 13 districts that she handles, there were 3 appeals from the Board of Review to the circuit court. In 2020, there were none whatsoever. The vast majority of these cases proceed like this case did, where you're faced with a particular factual question. In this case, was a child intoxicated? Was the child supervised? One could imagine a circumstance in which the question wasn't, did that happen? But the question was, does an intoxicated child necessarily constitute an unsupervised child? Or does allowing a child to become intoxicated meet the definition of maltreatment by neglect? Those sorts of cases, conducted in a more complex forum, would not be appropriate for a layperson advocate to handle. But a layperson advocate who appears and, again, merely engages with the facts presented by their party, summarizes the facts of a case overall, questions parties to the case about what those facts show, they're engaging in a very narrow scope of activity that does not affect the proceeding as a whole.
The problem with these kinds of proceedings, though, counsel, is that once it gets past the Board of Review hearing, then the only appeal is based upon the record. And so it's essentially the 29A kind of analysis. Was it clearly wrong? Were they outside the scope of their authority? That sort of thing. But in this particular case, some 12 years before this hearing, there was a finding made by DHHR as to maltreatment by neglect. And the party wasn't even aware that that finding had been made until much later, or did not participate in those proceedings. But that becomes, in terms of DHHR procedure, a definite black mark, because that person then later on could not be considered as, could not be approved as a foster placement, could not be approved as a relative placement. Would DHHR, if they were involved in an adoption process, would have to decline to approve that person as an adoptive parent because of that finding that was made this long time ago. And now we get to a point where the real practice of law in this case comes from not somebody representing the individual, but somebody representing DHHR, correct?
The question does turn on whether the advocate from the department was an attorney. Yes, Your Honor. The department doesn't believe that its rights were impacted by the advocacy.
What about the rights of the individual? I mean, I know this guy that's listed. I won't say his name on the record today, but he, when I knew him, was an excellent child protective services worker. did a great job. I mean, he really, really did. But I can see him being aggressive in terms of trying to protect the department. And in fact, he cross-examined this individual who had challenged the finding to the extent that he impeached the individual based on prior statements that were not made to him, but were part of a record that he was presenting. He had no personal knowledge. So he had no knowledge. He was defending his own record and cross-examined that woman. When he goes into cross-examination of a witness, does that constitute practice of law? He's not presenting facts.
It doesn't, Your Honor, and I think we can distinguish between the sort of the two issues you've identified in this case to illustrate why. Impeaching someone by pointing to prior statements they've made and questioning them about inconsistencies is still within the scope of building out just the facts of the case. What happened? Did you say this? Did you not say this? It wasn't informed by his personal knowledge, that's true, but it was still within the limited universe of factual inquiry. The point you mentioned earlier about the department's rights and about the fact that this is an appeal we're seeing 12 years, a hearing conducted 12 years after the initial finding was made. The decision to not raise the time delay as a defense the department could ordinarily raise as a jurisdictional time bar, that decision was not made by the non-attorney advocate. Not to breach confidentiality here, so just to speak generally, the department and the Attorney General's office have discussed in cases like this where jurisdiction can't be affirmatively disproven, where someone is essentially saying, I didn't know I had notice, or I didn't know that this finding was made, I want to appeal it now after the fact. If we can't disprove that fact, if we can't show when they got notice and show that they did know something 12 years ago, we're going to allow that person to at least get a hearing, come before the Board of Review, and address the facts of the case. This is a situation we want to be as accessible as possible and ensure, given the consequences you pointed to of a maltreatment finding, we want to ensure that people have an opportunity to come before the Board of Review. But again, that decision, that legal judgment about how to handle questions of jurisdiction and due process, those decisions aren't made by the non-attorney advocates. The department's rule only authorizes them to appear for the purpose of cross-examination, like you mentioned, and that's a discrete, fact-based inquiry separate from these sorts of proceeding-wide legal strategic judgments.
Would CP, under your rules, have been allowed to have with her someone to advise her, an advocate who was not a lawyer under this process?
Under the specific department rules, Your Honor, she could have someone there who could engage in the same sort of fact-based questioning that the supervisor did in this case. The rule applies to both parties. I noticed you used the word advise, and it's important to note that Friesen does not by its terms limit itself to factual inquiry. The department's rules here for the Board of Review only address these sorts of fact back and forth questioning. But Friesen does specifically mention that someone can have an advocate in these sorts of proceedings to advise them, but we know from other subsequent cases that that advice can't reach the level of controlling the overall proceeding. So yes, Your Honor, there can be non-attorney advocates there, lay people who assist with claimants in these cases. In the Board of Review, they can engage in fact-based questioning, but there need to be some limits on how far that can go, essentially. It's hard to draw an example of where this line would fall in Board of Review hearings because, again, Board of Review hearings are very limited. They deal essentially only with questions of fact, and they have very limited and streamlined procedural rules.
Well, counsel, let me ask you, you just described that what's good for the goose, that these rules apply to both sides, and then you put the caveat defining how far they went. Go back to the presentation from DHHR and the supervisor. Are there limits similarly on, quote, how far he could go in controlling the hearing before the ALJ?
Yes, Your Honor. And as a practical matter, it's not likely that any department employee would ever find themselves in the position of having to make that determination.
Well, is it the ALJ that's there to, we know that the supervisor made the argument in chief, cross-examined the respondent here, and made the closing argument. There was nobody else at that table other than the supervisor, was there? So how were they not controlling and thus exceeding the scope, as you've outlined, that they can't go that far?
So that turns, Your Honor, on the distinction between the specific hearing where the employee appeared versus the overall scope of the proceeding. Again, in Board of Review proceedings, this is not likely to occur, but for illustrative purposes, if there were questions like the jurisdictional issue Justice Hutchison asked about, if there were statutory interpretation questions, questions of law, the Attorney General's office exists to handle those sorts of issues. And the department and the Attorney General's office communicate about what hearings are proceeding before the Board of Review. If department employees have questions, they reach out to the Attorney General who assists in their district. If questions of law arise, which again is uncommon to say the least, that's when the Attorney General's office steps in, either before the hearing. I'm not aware of an instance where this has happened, but the Board of Review rules allow for memorandums of law to be filed after a hearing. In the rare circumstance that no issue of law is identified before the hearing, the administrative law judge allows those sorts of issues to be explored at the hearing without an attorney being present. Then an attorney could still, after the fact, file a memorandum of law addressing those questions of legal judgment and legal skill. So there's a broader set of protections in place that, again, we don't necessarily see in most cases, but that exist to protect against the unauthorized practice of law, separate from what the specific activity authorized by the rule.
On that issue, would there, if there was a need to file such a memorandum after the hearing, would that always be done by an attorney, or would the person who, the representative of DHHR who appeared, be able to do that under that rule?
Again, so I've asked the department, Your Honor, what the procedure is for these memorandums of law, and just discussions internally, we weren't able to identify an instance where one has been needed. But if there were, again, legal questions that arose in a hearing rising to this level, then yes, an attorney would prepare that filing. And that's not a function of the rules for the Board of Review don't authorize a non-attorney to file those. And it seems to us straightforward that that is the practice of law, and that is something that our office would handle.
Counsel, you have about 3 minutes left. If you'd like to reserve any time, you can do so, or you can wrap up.
If there are any questions that arise after my colleague's presentation, I'd like to address those. So I'll simply note the Board of Review hears 2,000 cases a year, uses procedures that it's had in place for over 30 years. These procedures are designed to be both efficient and accessible. These are cases that frequently involve underprivileged individuals acting pro se. And much like discussed in Friesen, the goal of these proceedings is to have a structure that a person can navigate without needing to be a lawyer or without needing to hire a lawyer. In these sorts of limited proceedings, the interests of practicality and the interests of justice are both served by allowing parties the benefit of assistance from anyone who they believe can help them with defined, isolated tasks. Thank you.
Justice, and may it please the court. My name is Zach Ritchie. I am the vice chair of the Unlawful Practice of Law Committee of the West Virginia State Bar. This court ordered the committee to file an amicus brief in this case and to address the question that was answered in part 1B of the petitioner's brief. And first of all, the committee appreciates that the order, the invitation to participate in these proceedings would be there for your questions. Briefly, 2 points. Our first is that we do agree with the petitioner best suited to answer, petitioner's counsel to answer those questions as it concerns the specific facts of his client, the DHHR. Our interest is limited, therefore, in this case, to the unlawful practice question. The second point I'll add, and then I'd be happy to take any questions that this court has, is that this case is an example of the difficulty, historically, the historic difficulty of sort of pinning down the unlawful practice. The definition has long been broad and necessarily difficult to define the unlawful practice, and there's a reason for that. It needs to be broad enough to capture the range of activities we ask our legal system, people and folks in our legal system to engage in, but it needs to be specific enough so people can conform their conduct in advance to what the practice is. So we understand that in cases applying that definition, they're going to be fact-specific, and every case is going to be a little bit different. As the hypotheticals asked by Justice Wooten and perhaps others shows, another case, the next case could be a little bit different, perhaps even in front of the Board of Review or in other administrative proceedings. And so the second point really is to ask this court and the bench and bar to be aware of unlawful practice concerns in administrative proceedings that may not be noticed. The circuit court in this case noticed and was very interested. We don't think that it came out the right way, but we would like in future for administrative law judges, circuit courts, and of course this court to be attuned to the potential for unlawful practice. And on behalf of the committee, we would like to educate so that these sort of problems don't happen at the beginning, and we're dealing with it later. So with that, if there are any questions about the UPL committee or our position in this case, I'd be happy to answer them.
Well, you, in your brief, your amicus brief, talk about, in essence, there's a very fine line, and the line is hard to define. Tell me how, in this particular case, when the department's representative, not the petitioner's, the petitioner below or the respondent in this case, where the department's representative essentially acted as prosecutor and cross-examined the respondent's, the respondent and I believe the respondent's daughter in these proceedings. If you don't believe he crossed the line, then what would he have had to have done to have crossed the line? Give me an idea here, what you think.
Certainly, Your Honor, I'd be happy to. I think the line, one of the lines, there are multiple factors that we've got to consider, and no one particular factor is going to control, so I'll say that at the outset. But one factor, I think, is thinking about the difference between bringing legal knowledge, specialized legal knowledge skills to bear. And that may include cross-examination tactics. But I think what historically the court's cases have looked at is the application of legal principles, rules, statutes, constitutions, and that sort of thing. So I think if we're going to try to draw a line here as clear as we can, knowing that there's no bright line, very few bright lines in this area, is that a distinction should be drawn between application of legal principles, legal rules to facts, or simply developing facts, whether through a rigorous cross-examination, and that is developing a factual record. I'm not suggesting, and I don't think petitioner is suggesting, that board review proceedings are perfectly designed to protect everyone's rights all the time. But that's not the question before the court. And so I think we look at the system that was designed, that's been working for 30 years, and historical practice being what it is, the line between factual development of a record in an administrative process where the referee, where the ALJ, doesn't even need to be a lawyer. I think there is an exception for when members of the Board of Review are presiding. But nonetheless, where the referee isn't even a lawyer, and I think even in this case, the ALJ may have even assisted, perhaps not much, the mother in elucidating facts. So it's in a participatory role. So I think the line, to come back to where I started, is on the application of legal principles, whether in pleadings, briefs, or argument, and the development of facts, including through rigorous cross-examination.
Here's a question, not a problem I have. Clearly, the lay representative can present facts, figures, or factual conclusions. Now, if the opposing party presents testimony that's contradicted by documents, it seems to me that clearly the department's representative can testify and say, here is a document that contradicts that. How, though, do you get from presenting that contradictory evidence to cross-examining and not engage in the practice of law?
Well, as I think of cross-examination in the context of what happened here, it's just a question of addressing credibility and addressing weight and eliciting evidence through cross-examination.
But how is that the presentation of facts, figures, or factual conclusions when you get into testing credibility?
I think eliciting testimony through cross-examination would fall under that category. I think in terms of credibility determinations and what we'll just call impeachment type of evidence, that again is concerned with the development of the factual record and honing it to the best that we can through this adversarial process, as informal as it may be, because those are the tried and true ways that we try to find the truth. And even in these very informal adversary proceedings, I think it would be difficult to carve out only particular types of cross-examination of facts, to say, well, only a lawyer can do that, when impeachment at bottom and credibility at bottom are common sense concepts that I think that laypersons can understand and laypersons can engage in as part of a factual effort to develop a factual record.
So you don't think, when this court said that it's not the practice of law if a layperson presents facts, figures, or factual conclusions, you don't think that contemplated, rather than cross-examining the layperson merely saying, Your Honor, I want to present this document which contradicts this, that it just present facts and figures. You're saying present includes cross-examination and impeaching credibility?
That particular aspect of the definition of the practice, I think, that you're quoting, I think could fairly include those concepts of cross-examination, but I think you also have to look beyond just that phrase and the definition to this court's cases, the cases of other states, especially more recent cases. Since the early decision, which was an old decision, there's been, of course, a proliferation of the administrative state in these proceedings, and so I think the courts around the country have been dealing with this, and the petitioner's brief did a fine job of surveying where other courts have come down on this and how they got there. It's a very good question, though, Justice Wooten, and I can't give a clean, clear, bright line answer just because it's a difficult subject on which to do that, but I think that's the best answer, and I'm certainly happy to defer to my colleague on if he has a better one.
Counsel, obviously we're here on Rule 20. It's a unique issue and potentially poised for a syllabus point. In your amicus, or can you point us, as you've certainly adequately described, the fine line, the challenge, and you've kind of attempted to set up some parameters of what's within the realm of appropriate conduct and what is beyond that. Is there any suggestion on what a syllabus point might look like? Because listening and having looked at this, such a syllabus point, however it's written, seems to me to potentially open up a whole new can of worms that would be applied, and somebody jumping up and saying, wait a minute, this is beyond just impeachment or relating to credibility. You're arguing fundamental issues of law and precedent, and therefore you're in violation of this syllabus point.
I think that's a really good question, and it's any syllabus point would need to be drafted with care. What I would suggest is that the court stay as close to the facts of this particular case as possible. The next case that comes, they can draw analogies, they can draw comparisons, and so what I would do is look in crafting a syllabus point that discusses it in the context of the Board of Review, not necessarily any other proceeding, but that focuses on, as the petitioner highlights, the factors, the character of the tribunal, the nature of the non-lawyer's conduct, the state and public interest, and the history. I mean, that may be a big syllabus point that considers those factors, but I think that's how you avoid maybe opening Pandora's box with general language or maybe too loose of language that raises these issues, because as petitioner noted in his brief, I think there are thousands of these Board of Review hearings every year and probably thousands of other types of administrative proceedings, and I think the last thing we need is to have the circuit courts clogged up with appeals on this very issue, and then this court's forced to resolve them all. So I would just suggest that hews closely to the facts of this case and resolving it that way in a syllabus point.
And I guess on that point, let me ask counsel whether we received a late filed amicus brief yesterday. According to the certificate of service that I just looked at, it was served on you by U.S. mail, so I don't even know if you've seen it. Have you seen it?
I have seen it, Your Honor. They did email it in addition.
Okay, well, that's great. So my question is, and this goes right to your answer, because the Department of Transportation is setting out some other quandaries that arise in administrative proceedings. And, this was just filed yesterday. I don't know that your board has even had an opportunity to review it or make any decision, but are you in a position today to give us your client's thoughts on because again, it seems that the DOT is saying, we'd like some guidance, and here's some examples of some other quandaries that come up. And you just answered the question, well, maybe you should stick to the case. Do you stand by that? My committee, we've heard, I'll try to answer your question. It was a long and winding question, so whatever.
Probably you'll have to suffer through a long and winding answer. We've been dealing with informal complaints from DOT attorneys about the public employees grievance process, where non-lawyer representatives acting as representatives have been undertaking what really looks like the practice of law from these, and again, admittedly informal complaints, not through the process, not in a case or controversy. And we wanted to bring in our brief, sort of highlight that as maybe an example of something that it could be the practice of law in an administrative proceeding when properly presented to this court or the UPL committee, because the filing of pleadings, the analysis of statutes by non-lawyer representatives in these proceedings, and that being quite a different case than what we have here. So I am certain that the DOT would like guidance. I know that our committee is always looking for guidance from this court as the ultimate arbiter of these issues, even in our proceedings. But crafting the syllabus point, I think, is a question that this court has to concern itself with greatly for all the cases to come. What I would suggest, and what we asked in our brief, is sort of the court noting, admonishing, or cautioning administrative law judges and the bench and bar to be on the lookout for unlawful practice in light of this court's cases, in light of the definition that this court has adopted, and hope that those issues may be resolved in the first instance, and we don't have to handle an appeal every time there's some question about that. And so it's a fine line. I'm not giving you a straight answer. necessarily on this. I know that my committee would appreciate guidance, but this court, of course, is limited in cases or controversies to issuing rulings that apply to the case before it. And I'm also concerned in the context of what our committee does, if there's potentially broad language that in a syllabus point that later could turn out that it goes too far in the other direction. And then do we need lawyers in every stage of these administrative proceedings, and the costs just explode. So I think there's a lot of concerns on both sides. It's difficult to draw a line, but I think from the committee's perspective, I can't speak for DOT, but we just want the court to be aware of these concerns in the administrative proceedings well beyond the Board of Review situation we have here today.
Counsel, just one, I'll try to be really quick here, but I know that in other areas, for example, like real estate law and closings and things like that, the committee has directed that non-attorneys can do certain things as long as there's sort of a supervision of an attorney. Do you have any proposals or thoughts as to whether we could, move in that direction in any way in this regard, and if so, how would you sort of do that if that were the case?
Right, and I think where you have an attorney who is an ALJ who is an attorney, I think in certain situations where that's required or that actually happens, you've got a little bit more oversight in the process and someone who is aware of the line, as blurry as it might be sometimes, between the by unlawful practice by the practice of law and simply the development of a factual record, for example. I think that would help sort of as a policy matter that folks downstairs might want to think about in designing or reforming these statutes. I think that would go a long way. But ultimately, as the case here shows, and I was talking to my friend before you came back, is that this case worked out in a way that it should. It went to the circuit court, and these issues were raised and litigated between lawyers in an adversarial proceeding in a judicial forum, and now it's here. And so I think that there are escape valves, there are escape hatches for when things do go wrong. Maybe the next administrative proceeding goes really wrong, goes off the rails, either in the factual development or in application of law by non-lawyers. And there are escape valves, even with a deferential standard of review. I think it is still possible for the circuit courts and this court to review those situations.
Any further questions? Anything additional, counsel?
No, sir. Thank you very much.
Thank you. You have 2 minutes for rebuttal if you so choose.
I think they agree. I'm not sure it's technically rebuttal, but.
I'm not sure either, Your Honor. And thank you. I'll just speak briefly to some other points raised by the specific questions Your Honors have raised. To Justice Hutchison's question about where is the line when cross-examination crosses into the practice of law, I'd certainly agree with what my friend said about the application of legal judgment and skill being the primary factor. But the other thing to emphasize here is that in these proceedings, the rules of evidence don't apply as they do in circuit courts. So conducting questioning and engaging a sort of back and forth isn't informed by the same sorts of legal analysis that it would be in a court proceeding. And I believe that speaks also to Justice Wooten's question, when does cross-examining cross into become a legal matter versus simply just contradicting someone else's testimony? And again, that's informed by looking at the nature of the forum and the informal proceedings. You can draw an analogy maybe to interrogation or activities done by law enforcement officers. Questioning someone, pointing out inconsistencies in their story isn't necessarily the practice of law if it's not done before a tribunal, a legal tribunal like a court. In an informal proceeding where the decision maker is a participant who assists in the back and forth, like we saw here, where ALJs participate in the questioning as well, it's not the same level of adversarial and legalistic process that you see in circuit court. Regarding how to craft a syllabus point here, again, I agree with what my friend said. We're faced with the facts of one particular case. We need a syllabus point that addresses specifically Board of Review proceedings. If this court wants to provide more general direction applicable outside the Board of Review, I would suggest using syllabus point 4 of Friesen as a starting point. That syllabus point didn't speak in terms of specific things that are permitted, but it gave boundaries of what is not permitted.
So, counsel, if I understand you, are you suggesting that if we have a syllabus point, it be focused, what I'm hearing you say, more on the forum in which the proceeding was being conducted, rather than what we heard a lot of is the types of questioning and the legal analysis and conduct of the individual in carrying out their role at the proceeding? So it should be proceeding focused rather than conduct focused.
Predominantly, yes, Your Honor. The proceeding creates, I believe, a rebuttable presumption that what is done here was not the practice of law. If it's an informal proceeding, largely not governed by the sorts of legalistic standards as a court. But as we saw in Friesen, even activities within those types of forums can rise to the level of practice of law. So what would be most helpful for both agencies and advocates in general would be guardrails, something that spells out when does advocacy go too far? Is someone conducting or directing the course of a proceeding overall? Directing a complex case in a holistic way would certainly describe the concerns raised in the Department of Transportation's amicus brief. So to also address Justice Walker's question, sort of system-wide, case-wide strategic decisions rise to the level of practice of law. But where procedural rules authorize discrete and limited activities that prevent these sorts of, like I said, holistic strategic decisions, that does not rise to the level of practice of law.
If you'd like to summarize, I believe your time is up, unless there's other questions.
Thank you,
I
counsel.
should know this, but the forum we're talking about in this instance was presided over by an administrative law judge. That was not a layperson, is that correct?
Correct, Your Honor. The hearings before the Board of Review are ALJs. I believe in this instance, this hearing officer is an attorney, but the Board of Review broadly does not use attorneys for the majority of their hearings. That issue was blessed by the Unauthorized Practice of Law Committee to use non-lawyers for the hearing officers. So now we're only faced with the question of whether the advocates can be non-attorneys. And I apologize for not reaching Justice Armstead's question.
Anything further? If not, thank you, counsel. This case will be submitted. Just trying to keep as much social distancing as possible. And if the clerk would call the next case.
Yes. Before I call the next case, I will let counsel know this case is being argued under Rule 19, and so you each have 10 minutes to present your oral argument to the court. We have placed a clock on the table to the left of the podium so that you can self-monitor your own 10 minutes. That 10 minutes does include the rebuttal for the petitioner, which you are entitled to make, so please remember to reserve that time for yourself. You'll notice that on the bench, we have put plexiglass between the justices, so they are able to remove their masks so that you can better hear their questioning and they are a sufficient distance from everyone else in the courtroom, so it is possible for us to do that here in our courtroom. We've also added plexiglass to the counsel table, so when you approach the podium, if you wish to remove your mask, please put the microphone cover on the microphone, and then you can present your oral argument. So with that, I will call the first case under Rule 19, oral argument, which is the third case on our docket today. Toby E. Bell and Janet Johnson versus Lee Perkins, Harry Perkins Jr., and others, docket number 19-0019, an appeal from the Circuit Court of Pocahontas County, West Virginia.
Good morning, counsel.
Good morning. I'm Paul Datch, and I'm from Lewisburg, and I represent Toby Bell and his sister, Janice Johnson. My father, who practiced law for many years in Lewisburg, used to have a saying, and that was that don't try to rule the living from your grave. And this particular case illustrates the wisdom of what he said. Back in the early 80s, Mr. Perkins, and you can get the earlier date, left a will in which he created an estate of what we're dealing with here today of 110 acres. It lies on the east bank of the Greenbrier River in Pocahontas County. He created in his will basically two tiers of beneficiaries. One was his 5 children, and they would have a life estate in this particular property, and then it would be on to the remainderment, which would be his grandchildren. He also provided, and what the sticking point is that each of his children, that is on that first tier, were to pay $100 a year to help maintain the cost and upkeep of this particular hunting camp. Unfortunately, things like a lot of families, some weren't interested, some were. In 1984, I was represented Toby Bell's mother on it, and at that time they were interested in trying to straighten out the mess that had been created by this will on it. So they brought a declaratory judgment in which they had asked that the court rule as to who owned what property. They were also getting accounting, and that they were then to basically hopefully straighten out the particular mess that had been created within this family. The Judge Jolliffe, that time, by the time we got around to getting everybody organized, it was actually 1989, and he ruled and set out the various heirs and who had inherited. At the time in 1984, 2 of the children did not want to participate, and so they just backed out and did not, I don't even recall that they even filed much of an answer. And so in any event, they acceded that this property should be divided into 3 portions. Judge Jolliffe ruled that this property was capable of partition, basically set out what each of the parties owned at that time, but he made no mention of anything dealing with $100 per year, per annum. After that, I then filed a partition proceeding that was filed in 1990, and the family basically had said, we're no longer interested in partitioning this, we're satisfied on it. Nobody challenged the fact that each was to get a 1/3 interest in the farm. Nobody raised any issues that we know of dealing with the $100 per year. 27 years then passed, of which the parties participated. One part of the family would get the property on the first week of hunting season, and the other party would get it the next week or the following week, and they would rotate that year by year. They worked out different business arrangements in which at one point they sold corn to actually now Governor Justice on it, and the money then went to into the farm. One of the heirs on it had even harvested some of the timber and used it in a cabin, as I understand it. In any event, they basically operated this Perkorosa farm for some 27 years. And then all of a sudden, one of the heirs decided that no, we want the Toby Bell's interest to be forfeited. His mother had died in 2004, and throughout all of the time that they had it, nobody had ever sent him a bill and said you owe anything on it. We don't expect you to pay anything, and so they just continued on it, using it, sharing it the same as they did with their relatives on it. When the suit was brought then, the lower court ruled that because of this provision in the will that had not been used or exercised for some almost 30 years or more, that became a flaw, and that these parties, without any ability to rehabilitate themselves, pay it, or do anything, they forfeited it. We don't know when it was supposedly that they were to have forfeited it. We really have nothing that indicated that there was ever an accounting. We certainly know that nobody ever made a demand on them for 30 years in order to do it. Any event, we then filed a response on this. We're raising one that the order itself does not say that the parties are to pay this $100. It's not subject to this. The judge ordered the division of the property and assigned the interest of it as it existed in 1989, and people have lived by it. We've also asserted waiver or estoppel, promissory estoppel. And basically we said that common sense would tell you that if you have ignored something for 27, now 30 years, that, by the way, let's not disturb it. I've pointed out that there are certain provisions that allow a family, by mutual agreement, to modify a particular will. The defendant has said that this agreement did not exist, or we can't show it, but we show that their practice and their acts actually show that they were in agreement as to how to use it on this property. And likewise, we've pointed out to the court that forfeiture is to be abhorred, and that you should look for any basic excuse to avoid forfeiture. And yet the lower court ordered the forfeiture of 1/3 interest in this real estate, and that's why we're here. We're asking that that decision of the lower court of Judge Dent be reversed.
Who's still left in the property? Judge Dent ruled that Lucille Perry's portion was forfeited. Who's still left? Which two of the original children's portions are still left?
I think counsel here probably can answer. That's more on his side of the fence. Lee Perkins, who was one of the sons, died here in the last 2 or 3 years anyway.
Lee was one of the grandchildren of Mason, if I understand.
Anyway, I think all of the children are now deceased, and it's been used by the grandchildren now for a number of years, although at one time there was kind of a blend of aunts and uncles and nieces and nephews.
All right, thanks.
Counsel, isn't the fact that the circuit court said that this $100 fee need not be paid until the lawsuit is resolved, doesn't that imply that it was still a valid requirement? I mean, you're arguing that because the court didn't specifically say you still have to pay that somehow went away, or the parties agreed otherwise.
That was the language that ended up after some discussion with counsel. Mr. Wills was the counsel at that time. Basically, we were thinking that as a question as to whether the parties were in conflict with each other. That's why the partition proceeding was filed in then 1990, to see if they could partition it, and they basically ended up telling the lawyers, no, we've resolved the issues. But no one ever then resumed paying or do anything on it. And so I can tell you that throughout all of my time as their attorney, I believed that that had just been waived and agreed to, that they were not going to pay it. My clients would have paid it, they'd pay it today if that was the issue. My client would be more than happy to rather write a check to his relatives than he would to me on it. And so I can assure you that if that was ever presented to them to pay it, they would have done it. But it's never been presented to them to give them that opportunity. Until this lawsuit was filed, they did not know that was an issue.
Justice Armstead talks about the language that says, until this lawsuit is resolved, but you say they thought it was waived. Upon what basis did they have the perception that that the obligation to pay the $100 had been resolved or waived? What point?
I think it was because throughout that proceeding that we had it, nobody had paid it. It hadn't really been paid. I don't even know today that anybody's paid it. There's an affidavit that says that the other side of the family had paid it, but they would have paid it to themselves. They never submitted anything or did anything to us. And so it was just assumed that they went along. The corn crop went into the support of the place, and the timber was used for sale of it, went into it. They just assumed that everybody was happy with the arrangement that was going on.
So I have a question, and I may not understand it very well, but it seems to me that the will, that the plain terms of the will are that $100 payment applies to the children, the holders of the life estates. But I don't see anything in the will that requires the grandchildren, the heirs, to make that $100 payment. What impact is that?
Well, that was one of the things that we had on it. Even by the time they were settling it, the grandchildren were coming into it, and they weren't paying it. And then one of the problems you had with the will, if the child forfeited it, did their interest then go to their children, or did it go to their siblings? And we contend that even if they forfeited it, it should have gone then to the remaindermen, not necessarily to their siblings. And so there was at least a great deal of confusion in regards to what that would be. And like I say, if the other side had at least made some demand earlier, I think that could have been straightened out. But
Didn't the 1989 order resolve that and say that if they didn't pay the $100, then the child and the grandchildren lost their interest?
No. Basically, it said that the two people who had not done it, that is those who did not want to participate, they lost it because they didn't want to participate, they didn't seem to care. Then the judge in his ruling set out what each of the parties, including the grandchildren, had, and he then made it vested, at least we contend, and believed it was vested at that point, and he made no issue or no statement that saying, by the way, this is then contingent on their paying or bringing even up to date any payment. There's nothing in that order that I could find or recall on it that says that this was to be paid.
Your time has expired. Thank you, counsel.
Thank you.
You've got, you'll be given a brief opportunity for rebuttal. We don't start the clock till you start.
Till the microphone covers it.
That's right.
May it please the court, I'm Jeff Pritt. I'm here on behalf of my clients, Lee Perkins, Harry Perkins Jr., Rem Perkins, and Annie Perkins, who are the descendants of one of the 5 children, well, actually 6 children of Okie Perkins. I would note for the record that Lee Perkins did pass away a few months ago. He was my primary client. However, his estate has not yet been probated, so I'm uncertain who owns his interest in the property, but that should not affect the result here, although it would greatly impact our case if this were remanded because he is our primary witness. Nevertheless, I would say that I see this case as a very clear-cut situation of res judicata or claim preclusion with an interesting property law twist. And the other element of this that I think is important to realize is that essentially here Mr. Dutch and his clients are trying to avoid exactly what they themselves did to other members of this family. To make sure the facts are clear, as Mr. Dutch indicated, Okie Perkins was the original owner of this property, a 112-acre camp called the Perkarosa in Pocahontas County. And Mr. Perkins died in 1964. He left a will. He had 6 children. He disinherited one of the children in the will. The other 5 children from whom my clients are descended from one of them, Mason, he left the camp to the other 5 children with this stipulation in his will that they each had to pay a $100 annual fee or else their title would be divested from the property. And over the course of time, Lee Perkins was designated the treasurer by his grandfather's will, and Lee kept track of the payments. And in 1984, Mr. Detch and his clients, not just their mother, but his clients, the grandchildren there that he represents today, Toby Bell and Janice Johnson, they filed a complaint for a declaratory judgment in the Pocahontas County Circuit Court and specifically requested in their complaint, and it's part of the appendix and is cited in my brief, that the interests of 2 of the 5 children of Okie Perkins, that their interests be divested. And one of those children was Kathleen McClung, and as I understand it, she did not have any children, but she had not paid the annual maintenance fee for about 15 years at that point when their case was filed in 1984. I think she quit around 71, I believe, so maybe it was 13 years. And one of the other children of Okie Perkins was James Perkins. He did have children. He had 2 children who were the grandchildren of Okie Perkins, and who, pursuant to the last will and testament of Okie Perkins, would have had an interest in this property. And their complaint that they filed in 1984 specifically asked that their interest in the property be divested because the annual maintenance fee had not been paid. We also, in 1984, established the pattern of how this was to work, because my client's descendant, Mason Perkins, again, one of the other children of Okie Perkins, he had died prior to 1984, but his sons, my client Lee Perkins and his brother Harry Perkins Sr., had continued to pay his share of the maintenance fee. So when they filed their case in 1984 in Pocahontas County, Mason Perkins' fee had been being paid by his children. Their fee was being paid by the sister, Lucille Bell, and the other party, Cecil Perkins, was paying his fee. So three of the fees were being paid and 2 were not, and of the 2 that were not, one of those was the living descendants were grandchildren. And as recited in our brief, Judge Jolliffe in 1989 specifically ruled that because the maintenance fees had not been paid that were attributable to 2 of these 5 children, that those interests were divested, and not just the parent or the child of Okie Perkins, but also the grandchildren, the children of the parents. So, and this was the specific relief that Mr. Detch sought on behalf of his clients, who he is here before today. In that order, Judge Jolliffe noted, as you have already asked Mr. Detch, that the parties had agreed that the maintenance fees would not be paid from 1986 until that case was resolved. That's in the order, and the reason for that is quite straightforward. In my renewed motion for summary judgment, I attached the accounting that Lee Perkins had filed in 1985 in response to Mr. Detch's case. And in that accounting, he had the complete records up through 1985 of who had paid what. And then they stopped while the case was pending. That case ended in 1989 with Judge Jolliffe's order. There was no further action taken at any point in that case. Near the end of the order in that case, it indicated that Mr. Detch and his clients could partition the property upon the filing of a proper petition, which is what they did. They did not proceed any further with the 1984 action that was resolved in 1989. They filed a new petition in 1990 in Pocahontas County to partition the property, and then did not pursue it. And it ultimately got dismissed for failure to prosecute in 1995. Now, from the time that this case, the 1984 case, was resolved, once that was resolved, we filed an affidavit from Mr. Perkins that the annual maintenance fees were continued to be paid after that point by Mr. Lee Perkins and Harry Perkins Sr. on behalf of their father's interest, Mason Perkins, and there was also another brother who was still alive at that time. So when that 1984 case was filed, there were 2 siblings still alive, his client's mother and Cecil Perkins, who I do not represent. And Cecil Perkins and the heirs of Mason Perkins continued to pay the annual maintenance fee up through the time that Cecil Perkins passed away in 2007. However, Ms. Bell did not pay her fee from 1986 forward at any point. She lived, as reflected in Judge Dent's order, until 2004. So she went approximately 18 years and paid no fee whatsoever at all. Judge Detch's order did not really specify what type of interest. He found that these heirs of Oakey Perkins, or Debezies, I guess, what type of interest they held, but I think, at least I've termed it, a fee simple determinable subject to an executory interest, which I'm getting that basically based on the Women's Club of St. Albans case, Justice Rouse's opinion that I cited in my brief. And basically, with a fee simple determinable, there's no waiver or latches or anything with that with respect to a fee simple determinable. If the action that divest title occurs, then it's divested. And ultimately, there are some, I guess, factual issues. Mr. Detch is talking about use of the property, and I think my clients would disagree with that, but the bottom line is that they did not pay the annual maintenance fee up through 2004 when his client's mother passed away. And our contention is that, again, it's just straightforward claim preclusion, res judicata. If we apply Judge Jolliffe's ruling to the facts, their interest had to be divested at least by 2004 when their mother passed away.
Thank you, counsel. Are there any questions?
Just one question. What is your position as to, under Judge Jolliffe's order, and it's picked up in the later orders, that there was no requirement for payment until the lawsuit was resolved? What is your position as to when that lawsuit was resolved?
Right. I think the way I view it, and I believe that we attached a copy of Mr. Detch's petition to our renewed motion for summary judgment because I went to Pocahontas County and got all the court records at that point. And basically, he had asked for a declaratory judgment, and that's what the order granted. And again, that order, near the end of it, said that they could file for partition upon the filing of a proper petition, and that's what they did. So I don't think there was any further order entered in that case. Of course, there was no appeal either, and I don't know. I mean, there was no activity in it ever since 1989, basically. So I guess it wasn't formally dismissed from the docket, but I don't know how it could continue or considered to be still active after all those years. And in fact, from their own actions, they're the ones who then filed a new action to partition the property, but they just didn't follow through on it. So I think they took the position that the 1984 case had been resolved by that 1989 order.
And did your client, I believe you said that your client continued to pay that fee, did they pay it after 1989?
Yes, my clients, Lee Perkins and his brother Harry Perkins Sr., who Harry Perkins Sr. died a few years ago, and his children are Harry Jr., Rem, and Annie, they all continued to pay that fee, plus on behalf of their ancestor Mason, who was one of the children of Oakey. And then Cecil Perkins was another child of Oakey, and Cecil was still alive. Cecil continued to live until 2007. He was the last surviving sibling, and Cecil paid the whole time until his death, as I understand it, per the affidavit of Lee Perkins. So that fee was paid many, many years ongoing after 1989, other than by them. They did not. And I think there was a question as who owned the interest now. Basically, Cecil Perkins' children sold their interest after Cecil passed away. They sold their interest to Lee Perkins. So Lee owns part of his father's interest, all of Cecil's interest, and then the interests of two of the other children were divested by Judge Jolliffe's order.
Thank you, counsel.
Thank you.
For the petitioner, I'll give you 1 minute of additional time for rebuttal.
There seems to be certain things that we can't agree
to pay their fees. We never set an amount on it or even told them that they were even paying a fee into themselves. We have never seen an actual accounting other than this affidavit. Now, when we filed the partition proceeding in 1990, we set out what the owners were or what their interests were at that time based on Judge Schall's order. And no one came to court to dispute it and said, no, you forfeited this, or you have to pay this, or this is going to continue. By ordering that it can be partitioned, he basically set into stone that these were the interests that the parties had. It was not contingent on $100. Now, I know that probably most lawyers these days don't check titles, but how on earth do you ever determine who owns this property when you have such a moving target? Even counsel here gets up and says, well, in 2004, it must have been divested sometime before then. Well, when was that? If somebody went to the courthouse and tried to look up who owned this property, there's no way that they could tell, and there's no way they could do it accurately. So when we look at this particular case, it has ramifications as to the ability to check titles, that there has to be something on record or people need to be noticed so that they can protect their property. My client went 27 years believing that he owned or his family owned a third interest in this property. And all of a sudden, the courts pull the rug out from under him, and we have seen absolutely nothing that really says that they ever paid it or that they were even asked to do it. So there are some things we've agreed on, and that is they spent 27 years with no action on it. Thank you.
Thank you, counsel. This case will be submitted.
All right, this afternoon, we will continue with the Rule 19 argument, which counsel, as you should know, provides for 10 minutes of oral argument for each side. That 10 minutes does include the rebuttal time for counsel for the petitioner, and you are entitled to that rebuttal time. There is a clock on the table to the left of the podium to help you self-monitor your time. We've also put plexiglass on the counsel table, so when you approach the podium to present your oral argument, if you choose to remove your mask, please put the microphone cover that you were given on the microphone. There is also plexiglass on the bench, so the justices are able to remove their masks because there is sufficient distance between them and anyone else in the courtroom. With that, I will call the fourth case for oral argument today, which is Orange, Scherich, and others versus the Wheeling Creek Watershed Protection and Flood Prevention Commission, docket number 19-1065, and this is an appeal from the Circuit Court of Marshall County, West Virginia. Counsel for the petitioner, you may proceed.
James Stebbins. I represent the petitioners in this matter, the Scherichs. It's various members of the Scherich family. This is a condemnation matter out of Marshall County. It involves the taking of 2 parcels of property totaling 265 acres and some oil and gas rights. The plaintiff in the underlying case is Wheeling Creek Watershed Protection and Flood Prevention Commission, which is a statutory entity that essentially took property to do flood control for the city of Wheeling. Our beef in this case has always been that we felt that Wheeling Creek took more property than it needed. It took 265 acres and has actually only used about 10 of those acres and have not used the oil and gas rights at all other than to lease them to other parties. So that's been sort of the bone of contention in the case. West Virginia Code Section 54-1-6 states that they can only take such quantity of land as is necessary, and so that's been sort of the underlying dispute. It has been a long time. This case was filed in 1990, and it was dismissed by the court sua sponte at a hearing that occurred in October of 2019. And just so the court is aware, this case involves what we call a quick take under West Virginia Code Section 54-2-14A. Under the traditional method for eminent domain, you go through all the procedures with condemnation commissioners and maybe a jury trial if necessary before the government takes possession of the property. Under the quick take, it's different. They get immediate possession of the property, they pay an estimate into the court, and then you go through the process of a commissioner hearing and, if necessary, a trial. And if the government had guessed wrong on what the estimate was, the landowner then gets the difference plus interest at 10%. In this case, we have identified for the court what we consider to be both procedural and substantive errors, and I don't have much time, so I'll be brief. The procedural errors are pretty simple. The court had a hearing where at sua sponte it was identified as a status conference, but at that hearing the court sua sponte dismissed the case. Didn't cite to any rule. The parties have surmised that it was either an involuntary dismissal under Rule 41B or that it was, in essence, a summary judgment ruling by the court. But it doesn't really matter what this court decides or which rule this court decides it was dismissed under, because both of those required the court to give my clients notice of an intent to dismiss and a reasonable opportunity to respond.
How did those proceedings come about? Did your client move for further proceedings? And if you did, then what was the reason for that?
Yes, Justice Walker. What happened, the case lay dormant for a long period of time. My clients, it was about 27 years since the money that had been deposited with the court had been withdrawn. My client, or clients I should say, then decided to hire counsel to pursue this matter further because it had never gone to a condemnation commissioner's hearing or to a jury trial. It had just sat dormant. It was on the docket of the court. It was not dismissed. And so in 2018, they filed this motion for additional proceedings. The court then entered an order setting the matter for a status conference. It was sort of an unusual pleading that I haven't seen before, where the court said that the matter was being set for a status conference, not to hear the motion for further proceedings, but because of it. That's the way the order read. So the court then had a hearing, and then, despite what it said in the order, went ahead and heard it, denied the motion, and then sua sponte dismissed the case. Our complaint about that procedurally is, under either Rule 41B or 56, the court had to give us prior notice of an intent to dismiss, and as case law from this court makes very clear, 15 days notice before it could do that. We never had a chance to brief. Our clients were clearly blindsided by the court's ruling. There was no indication given that there was any intent to possibly dismiss the case. So we feel that that's very clear. I'm sorry,
If
Your Honor.
we adopt your position on this and allow this, after, the long period of time that's expired here, and your client's able to get 10% interest a year, what would stop someone from, taking what has been deposited and then waiting for several years and bringing the case later on? I mean, what's the safeguard against that type of abuse of the process?
Yes, Your Honor. I think that's a good question, Justice Armstead. What we believe that provision is designed to do is to encourage the condemning authority or the government to efficiently pursue these type of proceedings. And if it doesn't happen, it's done at their peril. We believe, and that's sort of a major theme in this case, is, and I think this court needs to decide, who had the duty to push this case along? Was it the condemning authority, the government, or was it the landowners that had this duty to push it along? I don't think there is anything that keeps a landowner from sitting back. In fact, I represent the state on, or Department of Highways on some matters, and I have seen that happen where landowners will sit back and wait. It's a good investment for them. But if the state, or in this case, Wheeling Creek, chooses not to follow through on its statutory duty, it does so at its own peril. We believe very strongly that it is the government that has the duty to push these cases along and to prosecute. And we have several reasons for that I'd like to articulate for the court. First and foremost, we've cited to the court the Phoenix versus Ritchie case, which was really an inverse condemnation matter where the landowner was trying to get the government to file and follow through on proceedings, but this court made a very clear statement and said, a duty rests on the state to take necessary steps under our condemnation statutes to ascertain damages to the owner of private property. That's a very clear statement by this court that the duty's on the condemning authority to do that. We've also cited the court some non-condemnation cases, particularly Chenoweth and Keenan, in which this court clearly articulated that a defendant never has a duty to prosecute a case, and we were the defendant in the underlying case. Also, if you look at the statute, the quick take statute, which is what this case was filed under, 54-2-14A, specifically says that the condemning authority or the government shall not be entitled, without the consent of the defendant, to abandon the proceeding for condemnation, but the proceeding shall proceed to final judgment. That's what that statute says. We believe that, in effect, the circuit court's ruling allowed them to abandon the proceeding, and we don't think that's appropriate. We've also cited some cases from other jurisdictions, from Florida, Illinois, Texas, California, that have all specifically held that a condemning authority has the duty to prosecute and push the case along. And we would ask this court to please adopt those findings. I would also just tell the court that, my clients did not want this property to be taken. This was a taking, and it means just what it says. They didn't want to sell it. It wasn't on the market. Wheeling Creek came in and took it, and we believe that the exercise of that type of power, that fairness requires that it come with a responsibility to follow through on that. And these are important constitutional rights. Now, moving on, the court also, we believe, erred by making a series of findings on various theories or defenses that were never raised by Wheeling Creek in this matter, including waiver, estoppel, latches, accord and satisfaction, statute of limitations, and statute of repose. My clients had no notice prior to the hearing that those issues were going to come up with the court, no chance to brief it, but we have briefed it for this court, and I know this court does not like to hear new arguments on appeal, but unfortunately we've been placed in this position by the circuit court, which gave us no notice that it was going to be raising these issues. On waiver, I'll be very brief on each of these. It requires an intentional relinquishment of a known right. We've cited to the Sharp case, and that's a case where this court found that a jury trial in a condemnation case is something that you can waive, but it has to be knowing and intentional. In this case, we never even got to the stage where we could have waived a jury trial. Under the statute for the quick take, you have a condemnation commissioner's hearing first. You then have 10 days after the report of those commissioners is filed to file exceptions, and that's what triggers a jury trial. We never had the condemnation commissioner's hearing in this case. Nothing ever triggered a potential jury trial, so we could not have waived that. Estoppel was another theory the court relied upon. We cited the ARA case, ARA. It requires a misrepresentation or concealment of fact. There's no allegation or evidence in this case that we misrepresented anything or concealed anything. Statute of limitations or repose was another theory the court adopted. However, under 55-2-1, all statute of limitations and repose are told during the pendency of a suit. So as soon as this underlying lawsuit was filed, even though it's been 27 years since anything happened, the statutes were all told during that period under 55-2-1. With respect to accord and satisfaction, the court essentially found that by withdrawing the deposit or the estimate of just compensation that was made by Wheeling Creek, that constitutes an accord and satisfaction. The court was simply wrong on that fact. An accord and satisfaction means there's been a settlement, the parties agree to something and a payment is made. In this case, with a quick take under 54-2-14A, it specifically says that the acceptance of this payment shall not limit the amount to be allowed by the report of the condemnation commissioners or the verdict of the jury if there be one. In fact, that statute even says you can't even mention the estimate of just compensation at trial or before the condemnation commissioners.
Counsel, your time is not expired. If you would like to reserve any for rebuttal, I suggest you probably wrap up.
One last point I'll make before I sit down. If the court is inclined to dismiss this or agree with the circuit court that the case should have been dismissed due to the passage of time, we would ask the court to consider just putting the parties back to where they were beforehand and allowing our clients to have the property back. Thank you.
Thank you, counsel.
Good afternoon. May it please the court. Christian Turak on behalf of the respondent, the Wheeling Creek Watershed Protection and Flood Prevention Commission. Wheeling Creek commenced this condemnation proceeding on June 1st, 1990 to condemn certain real properties owned by the petitioners, the Scherichs. They condemned these properties in fee simple. The Scherichs answered this condemnation proceeding by counsel, also in June of 1990, and a hearing was held before the circuit court on June 15th, 1990, to determine whether Wheeling Creek was entitled to condemn the Scherichs' property. Neither the Scherichs nor their counsel appeared at the June 15, 1990 hearing. At the conclusion of the hearing, the circuit court found that the use for which the property was proposed was a public use, that the Wheeling Creek watershed had the right to condemn these properties, and that they were vested with title immediately as a result of that hearing.
That's a defeasible title, though, isn't it?
Yes, Your Honor, it's a defeasible title at that time.
Because you've got a whole bunch of other things you've got to do to make it a non-defeasible title, right?
Under the normal circumstances, yes, Your Honor.
Yeah.
Okay. Wheeling Creek deposited $97,000 as its good faith estimate of the value of the property with the court, and the Scherichs did not object to or otherwise appeal the June 15, 1990 order. They did not object to or otherwise appeal the condemnation of their property in any manner until very recently here. So at that stage, on June 15, 1990, the sole issue remaining in the entire proceedings was the fair market value of the properties that were condemned.
Let me ask you, counsel, obviously the petitioner cites 54-2-14A and the language shall proceed to final award or judgment. It sounds to me like what you're suggesting is emphasizing did not object or appeal. Are you suggesting that it was a final award or judgment back in 1990?
Well, not necessarily on that date. Now, they had the right to go ahead and have that hearing, have that appeal process, go to a jury trial if they would like to, but they didn't pursue that action. And again, the sole remaining issue on June 15, 1990, in the entire proceeding, the last remaining issue, is the value of the property. The burden of proof is on them to prove the value of their property, which they've claimed exceeded $97,000. And of course, my argument is that they had the burden of prosecution in bringing that forward as well. It's their failure to act that resulted in the situation that we have now.
And where in the statute does it describe their responsibility to act?
The statute does not describe their responsibility to act, but on the opposite hand, it does not describe Wheeling Creek Watershed's obligation to act either. It doesn't say who should act, who shouldn't act. The only issue that we have here is a West Virginia law. It quite clearly states that the sole remaining issue of the case, the value of the property, the burden of proof, is on the landowner to prove that. So from June 15, 1990 until the fall of 2018, the Scherich took no action to litigate the value of their property. The only action they took in the entire proceeding is in May of 1991, where they petitioned the court to obtain the $97,000 that had been previously deposited with the court almost a year prior. They accepted that, seemingly, based upon the circumstances that we know now to be the case, as full and complete satisfaction of the compensation for their property. They hadn't done anything in over 28 years. Now, more than 28 years after Wheeling Creek has obtained title to the property, a defeasible title to the property, Scherich's attempt to come forward and assert that Wheeling Creek somehow failed to fulfill its obligations to prosecute the proceeding of which they had the burden of proof. However,
can you cite any authority for converting a burden of proof to a burden of prosecution? I mean, you've made that argument, but there are a number of issues where, types of cases where a party has a burden to move forward and prosecute a case, but that doesn't shift simply because the burden of proof shifts. Can you cite any authority to support your argument?
Not particular to the condemnation action we're speaking about today here, Your Honor, but you have to look at the context of this case. And again, the sole remaining issue at this point is who has the burden of proof and the value of the property. And West Virginia is clear on that West Virginia law is clear on that issue. It's the Scherichs. They have the burden of proof on it.
Yeah, but that doesn't equate necessarily to the burden to prosecute, does it?
Not necessarily, but there's also nothing on the converse that says that it's not their burden of prosecution.
Well, let's back up a minute. Let's look at this thing procedurally. We've got some case law. I think the most notable case is, what is it, Damon versus Mancy? Essentially says that if you're going to dismiss a case for failure to prosecute, court's got to give the parties 15 days notice to file some kind of pleading. That didn't happen in this case, right?
No, Your Honor.
And there was no notice to either party in this case that the court was effectively going to grant summary judgment based on any number of grounds that the court came up with, right?
Not on the specific grounds, Your Honor, no.
Right. So what we have is, we have the parties asking, or one party asking for essentially filing a motion to institute further proceedings in the case. And we have a circuit judge then that says, hey, listen, we need a status conference in this case, figure out where we are. And then everybody gets there and the case gets dismissed either on a summary judgment or a Rule 46B. We don't know why he dismissed it, do we? No findings of fact or conclusions of law.
Your Honor, I was not at the hearing. I was not counsel of record at the time. All I have is the record before me.
I'm not pointing the finger at you.
My only point is I have the record before me just like you have. I don't want to speculate about anyone's motives or intentions or what people were thinking.
Well, the record,
but you're completely right.
The record does not reflect, if I am correct in my looking at the record and my clerk's looking at the record, there's nothing in the record that would show any briefing that was filed at or about the time of this status conference. There was no briefing of any kind, according to what's in the record.
That's what the record shows, Your Honor, yes.
Okay. So everybody shows up for a status conference, and all of a sudden, the judge starts pulling the trigger and starts shooting people out of the saddle. Is that a fair statement?
Respectfully, those are your words and not mine. But
I understand they're my words.
I think the transcript speaks for itself, Your Honor, yes.
Yeah, okay. I just want to make sure we agreed on the record.
All right. All right.
Giddy up.
So the question I have, how have you affected your client? How has your client not effectively abandoned this proceeding?
Well, they obviously instituted the proceeding. They fulfilled their obligations under Hardy-Ritchie, under the condemnation statutes by commencing the proceeding to condemn the property. They condemned the property. Now it flips. Now it flips to the landowner to now pursue their case as to the value of the property. My client, Wheeling Creek, said our good faith estimate of the value of the property is $97,000. We're going to deposit that in the court. Now you've taken it. Now I'm not arguing here that their acceptance of it is the end-all be-all. My point is they're arguing that it exceeds $97,000. It's their obligation to come forward and prove that. It's not my client's obligation to come forward and prove that it's not more than $97,000.
Let me ask you this question. Your client used the quick draw or the quick take.
Yes, Your Honor.
And so you're saying your client doesn't have any obligation, but as it sits right now, your client does not have good title because he has defeasible title, or the Watershed folks only have defeasible title in this real estate. So why could we not flip your last statement and say you've got an obligation to move forward and obtain a non-defeasible title to that real estate, just like he has? That's your obligation to prove that you're entitled to a non-defeasible title, and it's his obligation to prove the value. So don't you have an obligation on behalf of the state, on the statutorily created state agency? Don't you have an obligation to complete the task that you undertook whenever you decided to use the quick tape process?
I don't believe Wheeling Creek does, Your Honor. But I don't believe they do.
Okay.
Let me ask you, back on the procedural and the sua sponte ruling of the court. Obviously, we have very narrow exemptions to the notice requirement before ruling on a summary judgment. Are you suggesting that this case before the circuit judge fell into an exemption, or are you essentially conceding that the lower court erred in granting the summary judgment sua sponte?
If you're talking about the notice and hearing requirements, yes. I believe that both of them, under the totality of circumstances, it's not perfect, and I'm not saying it's perfect, under the totality of circumstances, I think that they were met. The judge scheduled it for a hearing. He says he wasn't going to hear the motion on further proceedings. The only logical conclusion of that is he wants to hear about this 28-year time delay. That's the only logical explanation I could come up with.
Where in our case law should it be just assumed that the opposing party should assume that that's the purpose for the meeting without it, or the conference without it being so specified?
Sure. There is no case law to that effect. I'm trying to put the pieces together on the record that I have here and about what reasonable assumptions may be. So I think under the totality of circumstances, again, it's not perfect, and it should have been handled in a different way, conceivably. But I do not think that rises to the level of being constitutionally deficient. What is Judge Hummel going to ask about in this circumstance? He wants to know why the 28 years, well, what's gone on these last 28 years? Why has there been a delay? Why is it just now being brought to my desk here after almost 3 decades? And I think at the hearing, there was ample opportunity to be heard on that issue. If you read the transcripts, Judge Hummel wanted to hear about it. He gave opportunity to hear about it. And of course, if there was no explanation for this 28-year delay in proceeding with this case. So again, I think it's not ideal, and I'm not saying it's ideal, and I would never hope that it would be a case like this, but Those are the facts that we have, and under this, again, the totality of circumstances here, I don't believe it was deficient.
Ask one other question real quickly, is just under the court's order, the court found an accord and satisfaction because the petitioner withdrew the funding, as I read it. And that is clearly permitted under the statute, is it not? So is that not error to find an accord and satisfaction when, in fact, the statute specifically allows them to take that funding and then still argue that additional funding is required?
Well, as Judge Hutchison pointed out, there's not a whole lot of detail to this order, so I wouldn't want to speculate on what Judge Hummel meant by the accord of satisfaction, but I can only come to the same assumptions that you've come to, which is by accepting that $97,000 and the 28-year passage of time, putting those two circumstances together, that's an accord of satisfaction. But the way the statute reads, if we're talking about June 16th, 1990, yeah, of course, that's not an accord of satisfaction. We're talking about May 1st, or I think it's May 31st when they received the deposited funds back or applied for those. I wouldn't argue that that's an accord and satisfaction, but I think once you accept the money and then wait 27 years later to come back, I think the only logical conclusion to that is that they've accepted that money as full and complete satisfaction of the compensation due to them for the taking of their property.
Thank you, counsel.
Thank you, Your Honors.
Counsel, I'll permit you 1 minute for rebuttal.
Counsel, do you have any insight as to why your client or counsel for your client did not appear at the hearing in June of 1990?
Yes, Justice Wooten. It's not in the record, but counsel and I have had a discussion about that, and what he told me is that he spoke with counsel for Wheeling Creek at the time and was told he could just file an answer and didn't need to go to the hearing. That's what I've been told actually happened. I will tell you, and I'll be very brief, my client did file an answer contesting both the amount of the take, the acreage, which in hindsight has proven to be a gross overtake of what they needed, and also the answer specifically addresses the issue of taking the oil and gas rights. And they never had a hearing on that issue at any time. I think, Justice Armstead, you're correct. Equating the burden of proof and the burden of prosecution, there's no case out there that they've been able to cite to that does that. 54-2A-14 specifically says you can't abandon the proceedings. That is what we think has happened here, as Justice Walker suggested. We submit they have effectively abandoned it. And the last thing I'll say, I think Justice Hutchison was talking about the feasible title. We believe on public policy grounds that when property is taken and held in the public trust in this manner, they should take it all the way through and get the feasible title. And if you just read the statute, it's very specific. 54-2-14A says, the title in the applicant shall be defeasible until the compensation and any damages are determined in the condemnation proceedings and the applicant has paid any excess amount into the court. The only way to fix it is to go back and go through these processes that they should have gone through to begin with.
Thank you, counsel. This case will be submitted.
All right, I'll go ahead with the preliminaries for counsel for the final case for oral argument today. You will notice that there is plexiglass on the bench between the justices, so they are able to remove their masks because there is sufficient distance between the justices and everyone else in the courtroom for them to do so. We also have plexiglass on the counsel table, and the chairs are at the end of each table, you will notice. So you may, if you choose, when you approach the podium, remove your mask and put the microphone cover on the microphone. If you choose not to, that's up to you. I'll remind counsel that under Rule 19, you each have 10 minutes to present your oral argument. That includes the rebuttal time for counsel for the petitioner. You're entitled to that, but please self-monitor your time. We put a clock on the counsel table to the left of the podium for you to do that. And in this case, I'll remind you that Rule 40 of the Rules of Appellate Procedure regarding confidentiality applies. Please refrain from using any last names, and we actually prefer that you use things such as mother, petitioner, respondent, okay? But do not use any identifying information when you're presenting your oral argument. And with that, the final case for oral argument today is David C. versus Tammy C., docket number 190786, an appeal from the Circuit Court of Kanawha County, West Virginia. And with that, counsel for the petitioner, please proceed.
Counsel, you may want to adjust that mic up. It looks like it's fallen over. And you can take your time, no rush.
May it please the court and Chief Justice Jenkins.
Can we get the clerk to do something with the microphone?
Looks like it needs to be tightened up. There we go.
May it please the court and Chief Justice Jenkins. My name is Michelle Johnson. I represent David C., the petitioner in this case. I wanted to thank you for letting me be here today for this very important issue affecting so many West Virginians. Some family courts have consistently refused to provide guardian ad litem reports to parents and attorneys. Regarding the family court judge in this case, she previously didn't give guardian ad litem reports at all and turned status hearings into final hearings. At least in one of my prior cases, it was overturned. Again, on April 22nd, 2019, she knew the father was not provided a guardian ad litem report or any documentation regarding this hearing, but she continued with the hearing regardless, and a sua sponte order was issued denying him and his entire family, including JB's brothers and sisters and his wife, contact with his daughter, JB. Other guardian ad litems have expressed their dissatisfaction with the system that if a parent has counsel, they get a report sometimes 10 days in advance of the hearing pursuant to West Virginia Code 48-9-301C, but they are pro se. They can only provide them a report 30 minutes before the hearing, and some guardian ad litems don't provide a report at all in family court. They just surprise the parents, especially if they're pro se. Now, this issue has been, on the table. This court knows about it. She presided in CLEs, and the Chief Kanawha County Family Court Judge, Ballard, stated, "There is no way to cure a late or absent guardian ad litem report except with a continuance. And the guardian ad litem report must be given to all parents and counsel. You can't just deny them a report." This is on the internet. That was in January 30th, 2019, where this judge presided over the Supreme Court CLE. Okay, let's turn to my client. The father is a coal miner who has been steadily employed in mining for approximately 19 years and has been subject to random drug and alcohol testing. He's never failed anything. The father risks his life on a daily basis to provide this day energy and also to provide for his family. This is quite a complicated case because it stems back years and years ago. Sometime around 2006, first of all, I wanted to let the court know that for the rest of this argument, I will refer to my client, David C., as the father, Misty C. as the wife of David C., Brandis B., the mother, David C. Sr. as the paternal grandfather, Tammy S. or Tammy C. as the maternal grandmother, and JB is the minor child. Okay, sometime around 2006, the wife and father separated for a short time. The father had a brief encounter with the mother, and JB was born. In 2007, the wife was shopping in a local store, convenience store at Toto's, when she was brutally attacked by the mother. This attack was confirmed and witnessed by multiple witnesses. The father was not involved in the fight, was initiated by the mother. The affidavits are in the court file.
Counsel, one moment. Clerk is going to assist with here. Okay. Why don't you wait just one more minute? She'll turn the mics back on. You may proceed.
Okay. Both the wife and father were cleared of all charges. However, apparently the mother went and spoke to the paternal grandfather, and as a result, the paternal grandfather took off to the picnic that the wife, the father, and all the minor children were at, and started shooting. And he shot up everybody in the picnic. I don't think anyone was severely injured, though. Well, as a result, he was indicted on 5 felonies and sentenced to 3 years and pled down to 2. He was also convicted of a felony in 1997 for unlawful wounding.
Counsel, you have about 5 minutes left for your argument. Maybe recommend that you focused on the assignments of error. That make sure we focused on the key issues in this case.
Okay. Well, the assignments of error is that there was no notice. The court violated his constitutional right to notice. There was no guardian ad litem report. It violates all the laws of the state of West Virginia, the U.S. Constitution, the U.S. case law. There was a sua sponte order from the judge that, there was no notice that she was going to deny the father, his wife, and all the siblings any contact with her sister.
Ms. Johnson, my understanding is in this case that your client got notice of this hearing from the guardian ad litem eventually. As I understand it, the grandmother had custody or had a guardianship, that it was revoked on motion of the biological mother. Then there was another guardianship granted in favor of the grandmother, and then the biological mother moves to terminate that one. And it's at that point that your client got no notice. And then whenever he appeared for the hearing on whether or not to grant, whether or not to terminate the second guardianship, the family court judge says, oh, by the way, you get no contact, without any kind of notice or any kind of motions having been filed by anyone. The family law judge goes, based upon this 2006 or 2007 shootout that they had at a family picnic, you have an alcohol problem and a violence problem, so you don't get any contact with your child, whom you've not had any contact with for the last 12 years. But until you show that you've attended Alcoholics Anonymous and gotten some kind of treatment for your anger. So is that what we're talking about here? Is that the issue? He didn't have notice that this was going to happen, and the family court overstepped its bound.
Your Honor, first of all, he didn't receive any notice at all for any of the hearings. Not 2011, not 2018, not this one.
He didn't receive notice. He didn't receive notice in the mail. In fact, they published it for the second hearing, I think, in the Charleston Gazette, and he happens to live in Beckley. But he had notice. He knew that there was a hearing because he knew to show up the second time, right?
Your Honor, all that was sent to him was a letter from the guardian ad litem and that was sent, it was dated March 19th, and it said that the guardian ad litem would contact him and arrange for a time to meet. That's included in my reply brief, and it didn't say that he was supposed to contact the guardian ad litem. It said she would be contacting him and going over stuff and was supposed to meet with him. But she never called him. Nothing ever transpired. The father didn't get a notice of hearing. He didn't get the petition for guardianship, the petition for modification or termination of guardianship. The father received absolutely nothing. So he was told, come to the hearing so that you can get visitation with your daughter. And the reason why this background is so important is I didn't think that the guardian ad litem report was accurate and complete. It was, this is a very long history. And I believe if it was accurate and complete, that the family court judge would have granted the visitation. The guardian ad litem report says that the mother and the wife had a fight 4 years ago. That's not what happened. That was back in 2007 when the mother attacked the wife. All these things, my client never did anything wrong. He doesn't have a history of alcoholism. He's constantly tested for drugs. He has 3 children he raised. And the reason why he did not want to be there, and he hasn't had a lot of contact, was because of the mother, because of some of the things that she has, kind of stirred things up that shouldn't have been stirred up.
Why was there any effort to continue the hearing on the mother's motion to modify the visitation?
Pretty much the court said, I wasn't there. I was not there. So the mother requested a continuation, but she was denied.
Is that the biological mother?
Correct.
Okay, thanks.
And she was denied. My client was sitting in the back. I didn't know this. He has a bit of a hearing deficit from working in the coal mines for 19 years. And the judge was just pretty much raging the whole time. And he was sitting in the back. She made her rulings before he was even able to say a word. All he said was no. And they did the child support formula. He's a very good father. He was awarded the primary custody of his other son from a relationship prior to his wife. And that was back in 2009. He's a good father. This is a good family. They live in a nice house, a nice log house on 7 acres. And they go boating, vacations. I just really think, the daughter wants to see the father in the family. And I don't see, how he's going to accomplish what this judge says.
Counsel, your time has expired. I've given you a little extra. If you would like to save any time, I'm willing to give you a minute or two of rebuttal if you'd wrap up now. That would be
Thank you.
Thank you, counsel.
Your Honors, my name's Heather Olcott, and I was appointed the guardian ad litem for the child in this case. She was 12 at the time that I was appointed. She's 14 now. She spent her entire life from the time she was an infant living in her grandparents' house. This is her maternal grandmother, paternal grandfather, with her siblings and her mother in the same house. Her mother was out a couple of times due to drug issues, and it's as far as I know, still out of the house due to her drug addiction. As you stated earlier, the first guardianship was filed in 2011 by the grandmother because the mother had a drug problem. That was granted. At the time, the father was not in the picture. The father was never in the picture in the full 12 years until a couple weeks before the hearing, this final hearing that's at issue. In the 2011 guardianship was later terminated after the mother sought rehab and some problem recovered from her addiction briefly. She came back to the house, but again in April of 2008, the grandmother filed another guardianship proceeding because the mother had relapsed. The father at that time was served by publication. The grandmother didn't know his whereabouts. She hadn't been questioned at length about that issue because it had never come up until after our final hearing. And in February 2019, the mother filed a petition or a motion to modify and didn't include the father on that petition or that motion at all. She didn't include his name or his address anywhere. However, in the appellate's brief, she has stated that the father received notice by certified mail of that petition. I can't speak to that. That's only in the briefs, but that's what's been stated.
Counsel, you say the father was not in the picture. Was he in fact paying child support?
I did find out later, yes, he was paying child support, and that I don't think came up until right before the final hearing. Obviously, as a guardian ad litem, I really wasn't looking on the issue of child support. I was looking on the issue, surrounding the child's residence and who should have custody and what, where she should be and could be safe. But yeah, as it turned out, he had been paying child support. And the custodial grandmother was receiving that support, and yet she said that she had no idea where he was. I don't believe she was receiving that support because the judge at the final hearing directed that the child support be redirected to the grandmother from the mother. So it's my understanding that the mother was still receiving the child support, but then the mother was out of the house, and at the final hearing, the child support was redirected to the grandmother.
Let me straighten something else up that
Sure.
I'm a little bit confused about. You have the biological father, and you have the biological mother. And the maternal grandmother is the one that had was granted the guardianship.
Yes.
Am I correct in reading this, my understanding that the paternal grandfather was living in the home with the maternal grandmother?
Yes, Your Honor. They had a long-term relationship. I'm not certain if they're married, but many, many years. So yes, the father's father and the mother's mother had at some point later in life become a couple.
And there's a second twist here.
Yes.
There's a second child who is not David C.'s child.
There were two other children. One became of age before I was involved.
Right. Well, the one that's still in the case is the niece of David C.'s current wife.
Yes. So my understanding is the other child's father is a sibling to the father, in this case's wife. Yes.
It's Misty's brother.
Correct. Is the father of the
So
sibling.
I raise those issues to ask this question. Does it seem reasonable to you that with all of that intertwining family relationship that nobody knew where David C. was?
I understand your speculation, but I believe in this instance it did make sense because there was such a history of violence and anger. Both the grandfather and the father were alcoholics for years. The grandfather stopped drinking in, I believe it was 2009, and got his life together and had been a positive figure for this child afterwards. The father, as far as I knew and as far as I was told by multiple witnesses and CPS reports and criminal records, he had continued to have drinking issues and had been completely separated from that family. Now, whether or not the grandmother could have poked around better and found that address, I don't know, because she was never questioned on that issue. It wasn't brought up during the hearing.
Or at least published in the Register Herald instead of the Gazette, right?
Possibly. I don't know how many years he lived at that address. I know that she knew he'd had a job and thought he had switched jobs or didn't know where he was working. As you know, coal mining jobs come and go, unfortunately, and I don't think she knew where exactly he was located. Again, she had more information about that, but I haven't focused on it since it wasn't part of the record, and she wasn't ever questioned about it.
So why didn't you share the report with the father?
Yes, that is a mistake, and it is because the case was assigned to me as a joint, combined case with this child and her sibling. Both were in the same boat, that their fathers had never been involved since their birth. This had been, twice this had gone before the court for guardianship, and the grandmother had taken guardianship of the children. This time I was assigned the case with both of them. I prepared the report jointly. I did gather quite a lot of information, which I think is clear from my report, and I had it prepared literally. It was due the day after the father finally called me. This was the first time any of us had heard from him. This 12-page.
Wait a minute, you had sent him a letter.
Yes, I found.
Telling him that you would reach out to him, which you did not do, and
Yes.
then he called you.
I reached out with him with the letter. I did not have a phone number, as it turned out. I didn't. And the address I sent the letter to was found on a 2007 criminal charge where he was a prohibited person in possession of a firearm, and he pled no contest. I found that address. I took a shot at it, and I assumed I had the wrong address when I didn't hear from him. I didn't have a phone number. No one had a phone number. They weren't in contact directly. So after I prepared this report, as a joint report, we were down to the day before it was due. I didn't want to expose all the confidential issues with the sibling to this father, and honestly, it was kind of a strange situation, and I didn't know what to do other than to protect the confidentiality of the other child that I was representing. When we came before the court, I did inform the judge that I hadn't provided him with a copy of the guardian ad litem report, and she went from there. So I've definitely learned now. If I am assigned a combined case like this again, I'll insist that it be separated, because I wouldn't have thought about this being an issue, that one father would pop up right before a hearing, and now I would suddenly have confidential information that I needed to share with them. So yes, that's a mistake on my part, Your Honor.
The paternal grandfather that has a relationship with the maternal grandmother that has custody, is he the gentleman that was involved in the altercation and shooting?
He is. However, the details presented by Ms. Johnson are, I didn't get the same information from the witnesses, from the criminal report, from various things. It seems to be unclear who started the shooting. Yes, the paternal grandfather showed up at the cookout, and then there was gunfire exchanged by both him and his son, who was the father in this case. It's not clear who started it, but yes, he was involved in that.
Were there criminal convictions?
Yeah, yes, he was convicted, and he served 2 or 3 years in prison. That was during the time when...
How about the son? Was he also charged or convicted?
The son, it was, I don't know if the charge ended up, if he ended up receiving any charges. It was transferred to circuit court as a felony case, and I don't know what ultimately came of that. I know he was convicted for a prohibited person possessing a firearm as a result of that incident.
So the paternal grandfather was convicted and sentenced to 3 years, and the father was convicted of being in possession of a firearm.
That's the details that I'm aware of, yes, Your Honor. And that was during the time that the paternal grandfather was still abusing alcohol to an extreme. He stopped that day, actually. I believe that was 2007. It was May 29th, he said, 2007. He hadn't had a drink since. Since then, he had been clean, had a job, and had been doing well since being out of prison.
Do you dispute that the father has been actively employed as a coal miner, where you are subjected to periodic drug screens and other types of tests?
When he called me on April 10th, he told me then that he was employed by Arch Coal. I didn't ask for how long. He didn't deny that there were alcohol abuse problems. He didn't deny that there had been a physical altercation with his father, aside from this one at the cookout with a gun. But prior to that, there had been a very serious incident that his father spent 20-some days in the hospital after being beat up by his son. I'm sorry, Your Honor, I've lost my train of thought.
Let me redirect you real quick. What's the status of the motion to terminate the guardianship, the last one that was filed?
It was denied because the mother had not showed a substantial change in circumstances.
No substantial change. So denied it, grandma still has the baby, and dad now has no ability to visit that child based upon what took place on the same day that the motion to terminate the guardianship was denied.
Yes, however, Your Honor, I'd like to clarify that the petition for guardianship, neither the one in 2011 or the one in 2018 addressed any sort of time with the father. It had not been addressed because he had not been involved at all. So
that's part of my concern here was that despite the fact that he didn't get notice and it was not essentially on the agenda, he shows up and say, oh, by the way, no, we're not going to terminate the guardianship, and oh, by the way, you don't have any right to see your child.
Yes, Your Honor. First of all, he learned about the hearing at the very least 11 days before, and he didn't request a continuance, not beforehand or at the hearing. He didn't bring counsel, didn't obtain counsel.
Was there any motion filed for him to have parenting time?
No, there was not, Your Honor.
So
He's
he
never
wouldn't have
filed
expected that issue would have been ruled on that day, would he?
He had noticed that would be an issue after the discussion with the maternal grandmother and my discussion with him on the phone. As I think you've probably read, that he showed up 2 weeks before the hearing or 10 days before the hearing and wanted to visit the child suddenly, showed up with his whole family and took her for a four-wheeler ride. Then she, the 12-year-old, all of a sudden wants to be around dad and wants to get to know her half-siblings. The grandmother informed me of this, and I recommended that the grandmother not allow any more visitation until we went to court in 11 days. Our hearing was 11 days away. There had been so many allegations of violence and alcoholism. There was even a CPS safety plan put in place against this man in the past. So
your time has expired. If you'd like to conclude.
So yes, Your Honor, I felt that it made sense given the concerns in this case, and I feel that his route should have been to file a petition for modification and then present the evidence that he showed later. Thank you.
Thank you, counsel. Well, counsel will allow 1 brief minute for rebuttal. Here.
First of all, she wouldn't have found anything in 2007 because the father was not in Raleigh County in 2007. So that's out. Somebody must have told her his address. The grandmother was being given the child support prior to the 2019 hearing. And regarding the petition for modification or termination, the only thing that the father received was a certified letter stating that there's a motion for the court to speak with the kids. I just want to reiterate that all this information was gone over. There were timely objections filed with tons of additional evidence, all kinds of notice that there was no report, tons of pleadings. The family court judge ignored every last one of them. The father was even evaluated by an addiction specialist and said he didn't need any treatment. Now, what she's talking about, all this stuff occurred in 2007, and that stuff in 2007 was not the father's fault. The father just pled no contest to a misdemeanor and got a $100 fine just because it was more convenient. Nothing happened to the father in 2007. It was all the grandfather. So the wife wasn't charged of anything. The father, all he got was a $100 fine because it was just a no contest plea, and it was nothing. So essentially, I was just trying to explain why the father just was hesitant about being around the mother. Now, I think that the grandmother and the paternal grandfather would welcome him with open arms. I think that this family needs to be reunited. I really think that that's what they wanted. But this court said no, because I don't think she had an adequate report. It was inaccurate, incomplete, it was wrong. He didn't receive notice, and everybody knew his address. I think the family court judge intentionally ignored the West Virginia and U.S. Constitution, West Virginia case law, U.S. case law, statutory law, family court and guardianship rules.
Counsel, you've, I think, made your argument very strongly, and I think we understand.
Okay.
If you conclude.
Yes. In conclusion, I would prefer that this case not go back to that same judge because, frankly, this happens again and again. No report. You go on there's a guardian ad litem, no report. You have to continue to appeal these issues. It's not right, it's not fair, and it's too time consuming.
I appreciate your argument. Thank you, counsel. This case will be submitted.